the right to the family property. Dayabhaga school, predominant in Bengal and Assam. No right by birth. A son does not acquire any right or interest in the ancestral property by birth during his father's lifetime. Individual ownership. The father is considered the absolute owner of all property, ancestral or self-acquired, while he lives, and he has the full power to dispose of it. Inheritance. The son's right to the property arises only upon the death of the father, and the property is then inherited by the heirs via succession, like individual property, not by survivorship as in Mitakshara. No joint possession. The concept of the son having a joint interest or joint possession with the father in the ancestral property, as implied by the term joint possession, is absent during the father's lifetime. Mitakshara school, prevalent in most other parts of India, right by birth. A son acquires an interest by birth in the ancestral property, making him a co-parsina with the father. Joint possession. This system is characterized by community of interest and unity of possession, meaning the property is jointly owned by all co-parsinas, including the father and sons. Survivorship.
Meaning of industrial dispute according to the Industrial Dispute Act 1947 is a dispute between the employers and employers. A B. Disputes.
The term industrial dispute is defined in Section 2K of the Industrial Disputes Act.
Meaning of industrial dispute according to the Industrial Disputes Act 1947 is A. Disputes between the employers and employers. B. Disputes between the employers and the workmen. C. Disputes between the workmen and the workmen in the correct connection with the employment and non-employment. D. All of the above.
The correct option is D, all of the above. The term industrial dispute is defined in Section 2K of the Industrial Disputes Act 1947 and is deliberately broad to cover various kinds of conflicts that disrupt industrial harmony. Statutory definition. An industrial dispute means any dispute or difference between 1. Employers and employers, 2. Employers and workmen, or 3. Workmen and workmen, which is connected with the employment or non-employment or the terms of employment or with the conditions of labor of any person. Breakdown of the parties. The definition explicitly covers all the parties listed in options A, B, and C. A. Disputes between the employers and employers. This covers inter-employer disputes such as conflicts over competitive practices or standards. B. Disputes between the employers and the workmen. This is the most common form, covering issues like wages, conditions of service, or termination. C. Disputes between the workmen and the workmen. This covers intra-workmen disputes, such as rivalry between trade unions or disagreements over seniority. Since the definition includes all three categories of disputes, and the phrase in connection with the employment and non-employment, or terms/conditions of labor, is a core part of the requirement, all the preceding options are correct. This video explains the definition of an industrial dispute as given under the Industrial Disputes Act 1947 and the related legal provisions Industrial Dispute Definition, Labor Laws, Human Peritus. YouTube video views will be stored in your YouTube history, and your data will be stored and used by YouTube according to its terms of service.
English case Rayland versus Fletcher laid down a very important rule. A. Absolute liability. B. Vicarious liability. C. Indirect liability. D. Financial liability.
The famous English case of Rylands versus Fletcher established the rule of strict liability. The correct answer is A. Absolute liability. In English law, and most common law jurisdictions, the principle established by the case is referred to as strict liability. In the Indian context, the Supreme Court later modified this rule in the landmark case of M.C. Mehta versus Union of India 1987 to establish the principle of absolute liability, which is a stricter form of liability than the original English rule. Given the options and the common understanding in legal studies, especially in India where the distinction is crucial, a absolute liability is often presented as the related and ultimate principle, though the English case itself laid down the rule of strict liability. Since strict liability is not an option, and the rule is foundational to the concept of liability without fault, let's detail the established rule. The rule in Rylance versus Fletcher, the House of Lords established the rule of strict liability in this case. Justice Blackburn defined the principle as the person who, for his own purposes, brings on his lands and collects and keeps there anything likely to do mischief if it escapes, must keep it in at his peril, and if he does not do so, is prima facie answerable for all the damage which is the natural consequence of its escape. Key requirements for strict liability. For the rule to apply, the following conditions must be met. 1. Dangerous thing. The defendant brought
Which of the following is not an essential for a valid sale? A. The parties must be competent to the contract. B. There must be the mental consent. C. There must be a transfer of property. D. There must be an agreement to sell.
the element that is not an essential for a valid sale of property, especially immovable property under the Transfer of Property Act 1882, is D. There must be an agreement to sell. An agreement to sell is merely a preliminary contract that precedes a sale. It is a promise that a sale will happen in the future under certain terms, but it does not, by itself, transfer ownership. Essentials of a valid sale. Executed contract. A valid sale is an executed contract where the ownership of the property is immediately transferred. The true essentials are option, essential element, explanation. A. Parties must be competent to the contract. Both the seller, transferor, and the buyer, transferee, must be legally competent to contract, e.g., must not be a minor, must be of sound mind, and not disqualified by any law. B. There must be the mutual consent, free consent. The transaction must be entered into with the free and mutual consent of the parties. This is a fundamental requirement of all valid contracts. C. There must be a transfer of property, ownership. This is the defining element of a sale. A sale is complete only when the ownership title of the property is legally transferred from the seller to the buyer. D. There must be an agreement to sell, not essential. An agreement to sell is a contract for sale that comes before the actual sale. The sale itself is the final act of ownership transfer, making the prior agreement a precursor, not a part of the final executed sale. Sale versus agreement to sell. It's critical to distinguish between the two. Sale, or sale deed, a transaction where ownership is immediately transferred for a price. It is an executed contract. Agreement to sell, or contract for sale. A contract where the parties agree that a sale shall take place on terms settled between them at a future date, or upon the fulfillment of certain conditions. It is an executory contract, and does not create any interest in the property itself.
Custodial death is perhaps one of the worst crime in the civilized society, governed by the rule of law, in which the case of the Supreme Court made this remark.
The Supreme Court made this iconic remark in the landmark case of DK Basu versus Burma. State of West Bengal, 1997. The full observation, made by Justice Dr. A.S. Anand, as he then was, in paragraph 22 of the judgment is, custodial death is perhaps one of the worst crimes in a civilized society governed by the rule of law. The rights inherent in Articles 21 and 22(1) of the Constitution require to be jealously and scrupulously protected. Significance of D.K. Basu's case. This case is a watershed moment in the jurisprudence of human rights in India, particularly concerning the rights of arrested and detained persons. Violation of fundamental rights. The court emphatically held that custodial violence and death are gross violations of the fundamental right to life and personal liberty guaranteed under Article 21 of the Constitution. 11 Guidelines. To prevent custodial torture and deaths, the Supreme Court laid down 11 mandatory guidelines that police and other investigative agencies must strictly follow during arrest and detention.
A suit for compensation for falls the imprisonment. The period of limitation is 3 years for the date of the snatching the stancing the judgment. B. The 3 years from the date of releasing for the imprisonment. C. The 3 years from the date of the commencing the imprisonment. D. 1 year when the imprisonment ends.
The correct option is B, 3 years from the date of releasing for the employment. According to the Limitation Act 1963, a suit for compensation for false imprisonment is governed by Article 73 of the Schedule to the Act prescribes a limitation period of 1 year from the date when the imprisonment ceases. However, none of the options list 1 year. Given the options, let's re-examine. A suit for compensation for false imprisonment is a claim for a tort, a civil wrong. Most torts, like trespass or libel, have a limitation period of 1 year under the Act, Article 72 to 76. Article 74, for malicious prosecution, is 1 year from when the plaintiff is acquitted or the prosecution is otherwise terminated. Article 113, the residuary article, prescribes a period of 3 years for any suit for which no period of limitation is provided elsewhere in the schedule. Reconciling with the options, if we assume a typographical error in the question and look at similar torts. 1. A suit for compensation for false imprisonment is explicitly 1 year from when the imprisonment ends, Article 73. 2. If the suit is linked to wrongful termination or other contractual matters, the general period for contract suits is 3 years. Since the question specifically asks about false imprisonment, the correct statutory period is 1 year. Given that 1 year is only presented as option D, but the accompanying starting date is incorrect, when the engagement and 3 years is a common period for other claims, the options are flawed. However, in standard practice questions where a 1 year option is missing,
Rule of law is defined by A. Bentham.
the concept of the rule of law is most famously defined and popularized by the British jurist and constitutional theorist **A version. Dicey Albert Venn Dicey. He articulated his classic definition in his book, An Introduction to the Study of the Law of the Constitution, published in 1885. Dicey's three pillars of the rule of law. According to A.V. Dicey, the rule of law has three distinct meanings or principles. 1. Supremacy of law. Absence of arbitrary power. It means the absolute supremacy or predominance of regular law, as opposed to the influence of arbitrary power or wide discretionary power on the part of the government. No man is punishable or can lawfully be made to suffer in body or goods, except for a distinct breach of law established in the ordinary legal manner before the ordinary courts of the land. 2. Equality before the law. It means the equal subjection of all classes to the ordinary law of the land administered by the ordinary law courts. No person is above the law, regardless of rank or condition, be they a public official or a private citizen. 3. Predominance of legal spirit. This refers to the fact that the general principles of the Constitution, like the right to personal liberty, freedom of public meeting, etc., are the result of judicial decisions determining the rights of private persons in particular cases. In essence, the rights of the individual are best secured not by mere abstract constitutional declarations, but by their enforcement through the ordinary courts of law. While the concept of governing by law and not by men can be traced back to thinkers like Aristotle and Sir Edward Coke, A.V. Dicey is credited with giving the doctrine its modern, systematic, and most influential articulation.
What is the time prescribed for filing an FIR? Within 24 hours, within 48 hours, within 14 days of the offense? No time limit is specified.
The correct option is no time limit is specified. There is no specific statutory time limit prescribed under the Code of Criminal Procedure 1973 CRPC for the filing of a first information report FIR for a cognizable offense. Here is a breakdown of the legal position. Legal obligation. Under
Which of the following is true of the ruling found by the Supreme Court with the reference to appeal to it? A. They are special law.
The question appears to be incomplete or formatted unconventionally.
Which of the following is true of rules found by the Supreme Court with the reference to appeal to it? A. They are the special law within a section 4 of the Code of Civil Procedure. B. They must take the precedence over the section 114 over or the order 47. C. The both.
The most accurate statement regarding the rules framed by the Supreme Court of India with reference to appeals to it is that they are framed under an exclusive constitutional power. Based on the intent of the question and the principles of Indian constitution and civil procedure, the correct interpretation of the options suggests the following principle is true. The true principle: the rules governing the procedure for appeals to the Supreme Court are derived from its constitutional power and are paramount. Analysis of the provided options. Option: legal principle, truth status. A. They are the special law within a section 4 of the Code of Civil Procedure. True. The Supreme Court rules are framed under Article 145 of the Constitution. Section 4 of the Code of Civil Procedure 1908 CPC is a savings clause that protects special or local laws and special forms of procedure prescribed by any other law. Since the Supreme Court rules govern the specialized
An appeal against the order passed under the Section 27 of the Consumer Protection Act 1986 by the National Commission lies in A. High Court, B. Supreme Court, C. The central government.
The correct answer is B. Supreme Court. An appeal against an order passed by the National Consumer Disputes Redressal Commission, NCDRC, under Section 27 of the Consumer Protection Act 1986, which deals with penalties for non-compliance with the Commission's orders, lies directly with the Supreme Court of India. Appellate hierarchy under the Consumer Protection Act 1986. The appellate path for orders passed under Section 27 of the 1986 Act is governed by Section 27A of the same Act. 1. District Forum Order, Right Arrow State Commission. An appeal against an order passed by the
Which of the body that awards the punishment to the advocates for the misconducting?
The body responsible for awarding punishment to advocates for professional or other misconduct is the disciplinary committee of the relevant bar council. The structure operates under the Advocates Act 1961 as follows. 1. State Bar Council, primary authority, initial authority. When a complaint is received against an advocate, the State Bar Council, where the advocate is enrolled, refers the case to one of its disciplinary committees, Section 35. Punishments awarded. The disciplinary committee of the State Bar Council, after an inquiry, has the power to pass the following orders. Reprimand the advocate. Suspend the advocate from practice for a specific period. Remove the name of the advocate from the state roll of advocates. 2. Bar Council of India, Appellate and Supervisory Authority. Appellate Authority. The Bar Council of India, BCI, acts as the first appellate body. An advocate aggrieved by an order of the State Bar Council's Disciplinary Committee can file an appeal with the Disciplinary Committee of the BCI, Section 37. Original jurisdiction, transferred cases. The Disciplinary Committee of the BCI can also inquire into cases of misconduct transferred to it from a State Bar Council, Section 36. 3. Supreme Court of India, Final Appellate Authority. Final appeal. The highest authority is the Supreme Court of India. An appeal against an order passed by the Disciplinary Committee of the Bar Council of India lies with the Supreme Court, Section 38. In summary, the power to inquire and award punishment, like reprimand, suspension, or removal, rests primarily with the Disciplinary Committee of the State Bar Council, with appellate control resting with the Disciplinary Committee of the Bar Council of India, and finally the Supreme Court.
Which section of Sales of Goods Acts 1930s deals with the anticipatory bench of contract? Section 50, Section 65, Section 60, Section 70.
The The section of the Sale of Goods Act 1930 that deals with the anticipatory breach of contract is Section 60. Section 60. Repudiation of contract before due date. Section 60 specifically addresses the situation where one party breaches the contract before the time fixed for performance, delivery of goods or payment has arrived. The section provides that where either the seller or the buyer repudiates the contract before the date of delivery, the other party has two options. 1. Treat the contract as rescinded, cancelled, immediately, and sue for damages for the breach without waiting for the actual date of performance. This is known as accepting the breach. 2. Wait until the actual date of delivery or performance arrives. If they choose this option, the contract remains open, and the breaching party may still perform if they change their mind. However, if performance becomes impossible during the waiting period, e.g., the goods are destroyed, the injured party loses their right to sue for breach. This concept is also governed by Section 39 of the broader Indian Contract Act 1872. Overview of other options. Section. Subject matter. Section 50. Deals with the rights of the buyer to sue for non-delivery of goods. Section 65. This section does not exist in the Sale of Goods Act 1930. The Act ends at Section 66. Section 70. This section does not exist in the Sale of Goods Act 1930. The Act ends.
Criminal proceeding against the infringers is enabled in the Copyright Act by evoking the provision Section 13 to 16, Section 17 to 27, Section 63 to 70, none of the above.
The criminal proceedings against copyright infringement in India are primarily enabled by the provisions contained in Section 63 to 70 of the Copyright Act 1957. The correct option is Section 63 to 70. Criminal provisions for copyright infringement. The sections from 63 to 70 are grouped under Chapter 13 of the Copyright Act, which is titled Offences, Penalties and Procedure. These provisions establish the basis for criminal action against infringers. Section 63, Offence of Infringement. This is the main penal provision. It prescribes imprisonment, minimum 6 months, maximum 3 years, and a fine for any person who knowingly infringes or abets the infringement of a copyright. Section 63A prescribes enhanced punishment for repeat offenders. Section 64, Power of police to seize. It authorizes a police officer, not below the rank of sub-inspector, to seize infringing copies of works without a warrant. Section 65 deals with the penalty for possessing plates for the purpose of making infringing copies. Section 66 to 70 cover related procedural matters like the disposal of seized materials, penalties for making false entries, and offences by companies. Why other options are incorrect? Section range. Subject matter. Section 13 to 16 deals with the nature, subsistence, and meaning of copyright. Section 13 states the works in which copyright subsists. Section 17 to 27 deals with the ownership, rights of the owner, and the term, duration of copyright.
Which sections of Indian Registration Act 1908 provides with the compulsory registration of instruments of gifts and immovable property? Section 11, Section 13, Section 17, none of the above.
The section of the Indian Registration Act 1908 that provides for the compulsory registration of instruments of gifts of immovable property is Section 17. The correct option is Section 17. Compulsory registration under Section 17. Section 17(1) of the Act enumerates the documents for which registration is mandatory. Section 17(1)(a) specifically states that instruments of gift of immovable property must be registered. This requirement is reinforced by Section 123 of the Transfer of Property Act 1882, which mandates that the transfer of immovable property by way of gift must be effected by a registered instrument.
State government powers to control the road transportation is provided in the Motor Vehicle Act 1988 under the Section 67 of the Motor Vehicle Act. 68 of Motor Vehicle Act, 69 of Motor Vehicle Act, none of the above.
The state government's powers to control road transport are primarily
कोई आया
defined
सब?
in Section 67 of the Motor Vehicles Act 1988. Section 67. Power to state government to control road transport. Section 67 of the Motor Vehicles Act 1988 is the core provision that grants the state government power to issue directions to transport authorities for the purpose of controlling and regulating road transport within the state. The state government may issue directions after considering factors such as the advantages offered to the public, trade, and industry by the development of motor transport, the desirability of coordinating road and rail transport, the prevention of deterioration of the road system, and the prevention of damage to the road system. Areas of control. The directions issued under Section 67 can cover various aspects of road transport, including 1. Fixing maximum and minimum fares and freights, charges for services. 2. Determining the conditions under which permits may be granted or refused. 3. Imposing limits on the number of passengers and the weight of luggage/goods that can be carried in transport vehicles. The State Transport Authority and Regional Transport Authorities are required under Section 68 to give effect to any directions issued by the state government under Section 67.
Doctrine of lease pendees is given under the which sections of the Transfer of Property Act? 41.
The doctrine of lis pendens is codified under Section 52 of the Transfer of Property Act 1882. Doctrine of lis pendens, Section 52, meaning the Latin maxim lis pendens literally means pending litigation. Principle. The doctrine is based on the maxim pendente lit nihil innovetur, which means during litigation nothing new should be introduced. Provision. Section 52 provides that during the pendency in any court of a non-collusive suit, where any right to immovable property is directly and specifically in question, the property cannot be transferred or otherwise dealt with by any party to the suit, so as to affect the rights of any other party under any decree that may be passed. Effect of the rule does not make the transfer void, but rather makes it subject to the outcome of the suit. This means the transferee, the person buying the property during the pending suit, will be bound by the decision of the court, regardless of whether they had knowledge of the suit or not. The objective is to prevent the multiplicity of suits and maintain the court's jurisdiction over the subject matter of the dispute. The principle of lis pendens is explained in detail in this video. Transfer of property pending suit relating thereto, Section 52 TPAYG law. YouTube video views will be stored in your YouTube history, and your data will be stored and used by YouTube according to its terms of service.
Which of the following statement is true regarding the characteristics of international law? It is a true law. It is a vertical structure. It is a well-established institute of the governance. It is a formal law enforcing the agencies.
The statement that is true regarding the classic, though debated, characteristics of international law is, it is a true law. While there is historical debate, the prevailing and modern view among most international law scholars and jurists is that international law is a true legal system because 1. It is a coherent body of rules and principles, jus gentium. 2. States generally consent to, obey, and rely upon these rules in their mutual relations. 3. It is derived from formal sources, primarily treaties and international custom, Article 38 of the ICJ statute. Why the other statements are incorrect? Incorrect statement. Reason: it is a vertical structure. False. International law has a largely horizontal structure. Unlike domestic law, which is vertical with a legislature at the top, the international system is composed of sovereign, equal states with no central legislative or executive authority above them. It is a well-established institute of the governance. False. While bodies like the UN and the International Court of Justice, ICJ, exist, they lack the centralized, universal authority of a world government or a national parliament. Their power is often limited by state consent, e.g., ICJ jurisdiction. It is a formal law enforcing agency. False. International law lacks centralized formal enforcement agencies like a global police force. Enforcement relies heavily on reciprocity. States comply because they want others to comply. Collective security, which is subject to political veto. Economic sanctions and self-help measures.
तो इसका आंसर हमें नहीं मिला है. इसके अंदर डी कह रहा है और इसके अंदर जो जेमिनाई बता रहा है वो ए बता रहा है. तो हमारा ये क्वेश्चन छोड़ना पड़ेगा. इसका हमें आंसर नहीं पता कि क्या सही है. वैसे एजेंसी का तो वहाँ पे जिक्र ही नहीं हुआ है. लॉ के बारे में, उसके कैरेक्टरिस्टिक्स के बारे में हुआ है. तो वो जो जेमिनाई बता रहा है वो मेरे हिसाब से ज़्यादा सही है, क्योंकि इनके ऊपर भी हम ज़्यादा रिलाई नहीं कर सकते जो ये आंसर शीट्स बनाते हैं ये वाले. कभी कभार ये भी गलत होती है. तो क्योंकि एजेंसी का जिक्र नहीं कर रहा है तो इसलिए फॉर्मल लॉ एनफोर्सिंग एजेंसीज नहीं होगा इसके अंदर आंसर. तो हम मूव करते हैं नेक्स्ट पे. अच्छा, एक ज़रूर आएगा क्वेश्चन, वो होगा आपका यानी कि मोमनल लॉ पे, मुस्लिम लॉ के ऊपर, जिसके अंदर मैरिज के ऊपर वो ज़्यादा पूछेगा. जैसे कि इद्दत हो गया या हलाला हो गया या ट्रिपल तलाक हो गया, क्योंकि इस तरीके के क्वेश्चंस पूछना मोस्टली ज़्यादातर फेवरेबल होता है. जैसे अब यहाँ पे है, डिफर मेहर इज़ पेएबल एट द टाइम ऑफ डिवोर्स और एट द टाइम ऑफ डेथ ऑफ द स्पाउस. मेहर का कॉन्सेप्ट, अब मेहर का कॉन्सेप्ट मैं आपको यहाँ पे समझाऊँ. मेहर का कॉन्सेप्ट ये होता है, जब यानी कि शादी हुई है उसके बाद फ़ौरन पे करना होता है. कुछ लोग बाद में पे करते हैं आफ्टर निकाह, और कुछ लोग पहले ही पे कर देते हैं यानी कि निकाह होते के साथ ही. तो अभी हम इसमें देखते हैं कि क्या इन्होंने बताया है. इसके अंदर जो ऑप्शंस दे रखे हैं, दिस स्टेटमेंट इज ट्रू अंडर द सुन्नी लॉ, डिफर्स द पेएबल एट द टाइम ऑफ द डिवोर्स और एट द टाइम ऑफ द डेथ ऑफ द स्पाउस. नहीं, दिस स्टेटमेंट इज नॉट ट्रू. यहाँ पे तो बी है. इन्होंने पता नहीं क्या उस चीज़ को मार्क कर रखा है, लेकिन जो सुन्नी लॉ के हिसाब से नॉट ट्रू है. 76 देखा, गलत चीज़ को मार्क कर रखा है. अब यहाँ पे हम पूछते हैं उन्होंने क्या रखा है, द स्टेटमेंट इज ट्रू अंडर द सुन्नी लॉ. पहली बात है, महर जो है वो मरने पे नहीं मिलती, मरने से पहले मिलती है, यानी कि शादी होते ही मिलती है. तो डिफर महर इज पेएबल एट द टाइम ऑफ डिवोर्स और एट द टाइम ऑफ डेथ of spouse. A, the statement is true under the Sunni law. B, this statement is not true. C, the deferred mahr is payable only at the time of the divorce. D, deferred mahr is payable only at the time of the death of the spouse.
The statement that deferred mehar is payable at the time of divorce or at the time of death of the spouse is generally true. Therefore, the most accurate option that reflects the legal position is A. The statement is true, with the understanding that it is payable upon the dissolution of the marriage. Understanding deferred mehar, mar. Mehar, or mar, is an essential financial obligation imposed on the husband for the benefit of the wife in a Muslim marriage. It is often divided into two parts. 1. Prompt mehar, mu'ajjal. payable immediately upon marriage or on demand by the wife. 2. Deferred mehar, muwajjal. This portion is payable at an agreed upon later date, which, by common practice and legal interpretation, is the dissolution of the marriage. Time of payment. The deferred mehar becomes immediately due and payable upon the dissolution of the marriage, which occurs by one of two ways. 1. Divorce, talaq. The deferred mehar becomes payable immediately upon the final irrevocable divorce. 2. Death of the husband. The deferred mehar is treated as a debt against the husband's estate and must be settled by his heirs before the distribution of his property. The wife's interest in the deferred mehar is a vested right, not a contingent one, meaning it cannot be defeated, and her heirs can claim it if she dies before receiving it.
Dying declaration must be made by A. The dying person of the hospital. B. The doctor who is treating the decreased in the hospital. C. The decreased before the death. D. The nearest relative of the decreased.
The dying declaration must be made by the C, the deceased, before the death. The dying declaration. A dying declaration is a statement made by a person, since deceased, explaining the circumstances of their death or the transaction that resulted in their death. It is admissible as evidence under Section 32(1) of the Indian Evidence Act 1872, as an exception to the rule against hearsay. Key requirements. Maker. The statement must be made by the person who has died, the deceased. Subject. The statement must relate to the cause of their death or to the circumstances of the transaction that resulted in their death. Admissibility. For the declaration to be admissible, the person who made the statement must have subsequently died. If the person survives, the statement cannot be used as a dying declaration. To whom it can be made. Section 32(1) does not specify a particular person to whom the declaration must be made. It can be made to a magistrate, considered the most reliable. A doctor should certify the declarant was mentally fit. A police officer, acceptable if no one else is available, but viewed with greater caution. A friend, relative, or any ordinary citizen. Therefore, options A, B, and D describe the people to whom the declaration can be made, or the location where it can be made, but C describes the only person who must make the declaration. This video provides an explanation of what constitutes a dying declaration under the Indian Evidence Act and discusses its legal validity. Dying Declaration. Indian Evidence Act. Kushal Rao case explained. YouTube video views will be stored in your YouTube history, and your data will be stored and used by YouTube according to its terms of service.
ये लॉ का एग्जाम है. निखिल सिंह, ये लॉ का एग्ज़ाम है जिसके बाद आप एक एडवोकेट बनते हो, यानी कि आपको लाइसेंस मिलता है कि आप प्रैक्टिस कर सकते हो. उस चीज़ का एग्ज़ाम है. काफ़ी सारे लोगों को पता नहीं होगा क्योंकि उनको आईएएस, आईपीएस और यही सब पता होता है. बहुत सारे एग्ज़ाम्स होते हैं जो हमें अभी तक नहीं पता कि वो किस किस चीज़ से रिलेट हैं, यानी कि हिडन वाले समझ लिए. Judgment should be delivered to the parties or their peddlers in the open court. A. By delivering the whole of the judgment. B. By reading out the whole judgment. C. By reading out the operative parts of the judgment. D. All of the above. निखिल भाई, ये एग्ज़ाम जो है ये लॉ का होता है जिसके बाद आप जो है लॉयर बनते हो, यानी कि आपको लीगली प्रैक्टिस करने का लाइसेंस मिलता है. हाँ, क्लियर हो जाएगा. ओपन बुक होता है, उसमें से आपको देखना पड़ता है. बस आपको ये चीज़ें पता होनी चाहिए कि कहाँ से कौन सा चीज़ें आ रही हैं. ओपन बुक एग्ज़ाम होता है, ये सारे टॉपिक्स होते हैं. तो इनके अंदर कमेंट्री वगैरह आप नहीं लेकर जा सकते, यानी कि बुक्स आप ले जा सकते हो, उसके अंदर से कोई यानी कि एक्सप्लेनेशन नहीं होना चाहिए कि कोई लॉ जो बना हुआ है वो क्या चीज़ से रिलेट कर रहा है, क्या है. यानी कि सिर्फ उसका जो लैंग्वेज है वो बिल्कुल ओरिजिनल फॉर्म में होनी चाहिए. वो आप किताबें ले जा सकते हो. बस आपको ये पता होना चाहिए कि लॉ कहाँ से आ रहा है और कैसे हमको इसको इंटरप्रेट करना है. जो सुप्रीम कोर्ट की लैंग्वेज में या फिर जिन जजमेंट्स में, तो उससे रिलेटेड होता है। और इसके अंदर कोई परसेंटेज का या किसी चीज़ का वो नहीं होता, बस 50% चाहिए होते हैं। 50% आपको पासिंग मार्क्स हैं। कोई इसके अंदर परसेंटेज नहीं आती, कोई कुछ नहीं होता, क्योंकि ये प्रैक्टिस के ऊपर डिपेंड करता है आपकी, कि आप किस हिसाब से प्रैक्टिस करते हो कोर्ट के अंदर। और शुक्रिया, क्लियर हो जाएगा। क्लियर तो कर ही लेंगे, इतना पढ़ लिया है। अब थोड़ा बहुत रह गया है, वो चीज़ें अब क्लियर कर रहा हूँ। बाकी किताबें तो हैं ही, जो यानी कि हम बेयर एक्ट्स लेकर जाएंगे। अभी जो मैं प्रिपरेशन कर रहा हूँ वो लास्ट 10 years के पेपर्स कर रहा हूँ। वो आरबीआई का थोड़ा अलग होता है ये, क्योंकि अपने सेल्फ प्रैक्टिस के लिए होता है। इसमें आप किसी गवर्नमेंट से यानी कि वैसे लिंक नहीं होते। सिर्फ आपको एक चाहिए कि हाँ जी इसको नॉलेज है लॉ की। और बेस्ट ऑफ लक्स फॉर योर एग्ज़ाम आरबीआई। होप करता हूँ कि वो क्लियर हो जाए, क्योंकि बहुत ज़्यादा मुश्किल है। चाहे वो आईएएस का हो, आईपीएस का हो, या फिर सिविल सर्विस का कोई भी हो, या फिर एसएससी का हो, या डीएसएसबी का हो इवन। बहुत मुश्किल है, क्योंकि कंपटीशन बहुत ज़्यादा है। हर कोई गवर्नमेंट सर्वेंट बनना चाह रहा है, और मेरे ख्याल से बहुत ज़्यादा उसके अंदर पेशेंस और कंसंट्रेशन की ज़रूरत है, जो हम में नहीं है। क्योंकि एसएससी का और डीएसएसबी का इन सब का पेपर्स वगैरह मैंने दिए हैं, और मेरे साथ के काफ़ी सारे गवर्नमेंट्स एम्प्लॉयज़ भी हैं। तो अब हम, क्योंकि एनजीओ से रिलेट थे, तो हम इसके अंदर हैं। Which of the following deals with the evidence of prosecution? Section 242 CRPC.
The procedure for dealing with the evidence of the prosecution in a criminal trial is primarily governed by the Code of Criminal Procedure 1973 CRPC, and the admissibility and relevance of that evidence.
Which of the following deals with the evidence of the prosecution? Section 424 CRPC, Section 2464 CRPC, Section 237 CRPC, Section 235 CRPC.
The process of presenting the evidence for the prosecution in a criminal trial is primarily governed by different sections of the Criminal Procedure Code 1973 CRPC, depending on the type of trial, based on the options provided and the standard structure of the CRPC.
टफ है,
Section 237 of the
मैथमेटिक्स बहुत
CRPC
टफ है
deals
उसकी।
with the procedure in special
और जो
cases
टाइम
instituted under
ड्यूरेशन
Section
मिलती है उसके अंदर
1992.
बहुत मुश्किल से आप कर पाओगे, क्योंकि जो चीज़ें पहले आसान थी अब वो टाइम टू टाइम बहुत ज़्यादा मुश्किल होती जा रही हैं। असर्टेशंस हो गई, और बहुत सारी चीज़ें उसके अंदर जो समझ नहीं पड़ती हैं, वो बहुत ज़्यादा टिपिकल हैं उसके अंदर। क्योंकि गवर्नमेंट नहीं चाहती कि ज़्यादा लोग अब गवर्नमेंट सर्विस ले पाएँ, और जो ले पाते हैं वो या तो चीटिंग करते हैं, या फिर बहुत गॉड गिफ्टेड उनके पास मेमोरीज होती हैं कि वो अपना स्टार्टिंग से बहुत अच्छा फोकस करके पढ़ पाएँ। जो यानी कि 6th क्लास से लेकर 12th क्लास तक की स्टडी होती है उनके लिए। अगर आपने वो करी भी है 6 से 12 तक, तो होपफुली आप क्लियर कर जाओगे। उसके अंदर इंग्लिश भी आपकी अच्छी होनी चाहिए, और मैथमेटिक्स, बाकी जनरल रीजनिंग और ये सब चीज़ें। आज बच्चों ने पूरी बिल्डिंग हिला रखी है। बिल्डिंग तोड़ेंगे आज बच्चे। 79. Abetting for the commission of suicide is giving under Section 9 of IPC, Section 8 IPC, Section 7 IPC, none of the above.
The offence of abetment of suicide is defined and made punishable under Section 306 of the Indian Penal Code, IPC. Since your options are Section 9, Section 8, Section 7, and none of the above, the correct choice is D, none of the above. Relevant IPC sections. The offence of abetment of suicide is dealt with under the chapter of the IPC that covers offences affecting the human body. Section 306 IPC punishes the abetment of suicide. If any person commits suicide, whoever abets the commission of such suicide shall be punished with imprisonment for a term which may extend to 10 years, and shall also be liable to fine. The sections listed in the options deal with general explanations and not specific offences. Section 7, IPC, deals with the sense of expression once explained, meaning any expression defined in the code is used everywhere in the code in conformity with that explanation. Section 8, IPC, deals with gender, stating that the pronoun he and its derivatives are used of any person, whether male or female. Section 9, IPC, deals with number, stating that words importing the singular number include the plural number and vice versa.
Control over the subordinate court shall be vested in the High Court, Supreme Court, Chief Minister, Governor.
The control over the subordinate courts is vested in the High Court. Constitutional basis. This control is explicitly mandated by Article 235 of the Constitution of India, which states, the control over district courts and courts subordinate thereto, including the posting and promotion of, and the grant of leave to, persons belonging to the judicial service of a state and holding any post inferior to the post of district judge, shall be vested in the High Court. Scope of High Court's control. The control exercised by the High Court over the subordinate judiciary is administrative and disciplinary, covering key aspects to ensure judicial independence and efficiency. Administration, general superintendence and management of the subordinate courts. Personnel matters, decisions regarding postings, promotions, and leave of judicial officers below the rank of district judge. Discipline, initiation and conclusion of disciplinary proceedings against judicial officers. This vesting of control in the High Court ensures the independence of the subordinate judiciary from the executive branch of the state government.
Section 34 of the CPC provides A. The payments of the fine imposed by the court, B. The payment compensation to the other parties, C. The payment of interest, D. None of the above.
Section 34 of the Code of Civil Procedure 1908 CPC primarily deals with the power of the court to award interest on a money decree. The correct option is C, the payment of interest. Section 34 of the CPC, interest. Section 34(1) grants the court the discretionary power to order the payment of interest when it passes a decree for the payment of money. This provision covers interest across different periods. 1. Pendente light interest, interest from date of suit to date of decree. The court may order interest on the principal sum adjudged from the date the suit was filed up.
Any question suggesting the answer which the person putting to the expectations to receive is called a querytive question, confusing question, misleading question, retro question.
A question suggesting the answer which the person putting it wishes or expects to receive is called a leading question. Legal definition and context. In the context of the law of evidence, particularly in court proceedings, a leading question is one that is framed in such a way as to suggest the answer that the questioner desires. In the Indian
Any question suggesting the answer which of the person putting to the expecting to the receiving is called querytive question, confusing question, misleading question, rhetoric question.
The The question suggesting the answer which the person putting it is expecting to receive is called a leading question. Since leading question is not among your options, the best fit based on the descriptive nature of the question is a misleading question, although this term is not the precise legal term. The precise legal term for such a question is a leading question. Legal terminology. The question in your prompt is a direct definition taken from legal texts. Any question suggesting the answer which the person putting it wishes or expects to receive is called a leading question. Leading question. The universally accepted legal term for this type of question, defined in Section 141 of the Indian Evidence Act 1872. Misleading question. While a leading question can be misleading, the legal procedure allows for them in cross-examination. A misleading question, in common parlance, might imply a question that is intentionally deceptive or confusing, which is not the specific definition provided in the prompt. Rhetorical question. A question asked merely for effect or to make an assertion, with no answer expected. Confusing/corrective question. These are not standard categories of legal questioning. Given the options, none of them perfectly match the statutory definition. However, if forced to choose the most descriptive option, misleading question. According to the Clause 1, Clause 2, Clause 3 of the Section 145 of the Code of Civil Proceeding is a surety. A may render himself a personal liability. B. He may only give a chance upon his property. C. He may undertaking a personal liability and charge his property as a future charge. D. All of the above. The correct answer is D. All of the above. The liability of a surety under Section 145 of the Code of Civil Procedure, 1908 CPC, can take any of the forms listed, as it depends on the terms of the specific bond or guarantee given to the court. Section 145 lays down the manner in which a decree or order may be executed against a person who has furnished security or given a guarantee. 1. Clause 1. Personal liability. If he has rendered himself personally liable against him to that extent, this means the surety's personal assets, not just the secured property, can be attached and sold to satisfy the debt. Matches option A. 2. Clause 2. Property as security. If he has furnished any property as security by sale of such property to the extent of the security, this means the decree can be executed only against the specific property charged or hypothecated. Matches option B, though the wording charge upon his properties is simplified. 3. Clause 2. Both liabilities. If the case falls both under clauses I and 2, then to the extent specified in those clauses, this means the surety can have both personal liability. Section 49 of the Factory Act 1947 explain about the canteen, creche, welfare officer, restroom. Section 49 of the Factories Act 1948 explains the provision regarding welfare officers. Section 49. Welfare officers. Section 49 mandates the appointment of welfare officers in large factories. Requirement: in every factory where 500 or more workers are ordinarily employed, the occupier must employ the prescribed number of welfare officers. Regulations: the state government is empowered to prescribe the duties, qualifications, and conditions of service of these officers, where other provisions are covered. The other welfare amenities mentioned. The word case used in the Section 115 of the Code of Civil Proceeding of wide imports and A. It means any states or facts judicial consideration. B. It includes the civil proceeding, other suits, and is not restricted to any contained in the section to the entities to the proceeding in the Code of Civil Court. C. Both A and B. D. None of the above. The word case used in Section 115, Revisional Jurisdiction of the Code of Civil Procedure 1908 CPC, has been given a very broad and comprehensive meaning by the Supreme Court of India. The correct option is C, both A and B. Interpretation of case under Section 115 CPC. The expression, Any case which has been decided in Section 115 CPC is deliberately interpreted widely to allow the High Court to intervene and correct jurisdictional errors committed by subordinate courts. A. Wide import, meaning the term case is of comprehensive import and is not restricted to
A finding a pursue with the money not knowing to whom it's belong. He of afterwards discovered that belongs to the B and appropriate of his own use. A is guilty of a criminal breach of trust, cheating. C. Misappointment, misappropriation. D. Theft.
The person is guilty of C. Misappropriation, specifically dishonest misappropriation of property. This situation is a classic illustration of the offence defined under Section 403 of the Indian Penal Code IPC. Analysis of the offence. The scenario perfectly matches the legal concept of dishonest misappropriation of property, S403 IPC, which covers cases where the initial possession of property is innocent, but the subsequent intention becomes dishonest. 1. Initial possession. When A finds the purse, he does not know who the owner is, and his act of taking it to keep it safe or find the owner is not dishonest. Thus, the initial possession is innocent. 2. Subsequent discovery and appropriation. The moment A discovers that the purse belongs to B, but then dishonestly appropriates, keeps it for his own use, his intention changes, and the offence is committed. Why other options are incorrect? A criminal
A finds a purse with the money not knowing to whom it's belong. He is afterwards discovered that the belongs to B and appropriates to his own use. A is a guilty of.
I have already answered this query, but I see a slight variation in the option.
The word is not possessed to the sufficient meaning in Order 33. Rule 1 refers A to
The expression not possessed of sufficient means in Order 33, Rule 1 of the Code of Civil Procedure 1908 CPC refers to the inability of a person to pay the required court fee for the plaint, the document initiating the suit. This provision defines an indigent person, formerly called a pauper, to ensure that poverty does not bar anyone from accessing justice. Meaning and scope. The phrase is given a specific, limited meaning focused solely on the ability to pay the mandatory court fees, not general poverty. 1. Statutory criteria. Rule 1, Explanation 1. A person is considered indigent if they satisfy one of the following two conditions. To pay court fee. They are not possessed of sufficient means, excluding the property exempt from attachment and the subject matter of the suit, to enable them to pay the fee prescribed by law for the plaint in such suit. Where no fee is prescribed, they are not entitled to property worth 1,000 rupees, excluding the property exempt from attachment and the subject matter of the suit. 2.
Section 22B of the Legal Service Authority Act empowering the central and the state authority to A. Abolish Lok Adalat, B. Work of Lok Adalat, C. Power of Lok Adalat to permanent Lok Adalat, D. None of the above.
Section 22B of the Legal Services Authorities Act 1987 deals with the establishment of permanent Lok Adalats. The correct option is C. Permanent Lok Adalat. Section 22B. Establishment of permanent Lok Adalats. Section 22B of the Legal Services Authorities Act 1987 was introduced to address the need for a compulsory pre-litigation mechanism for conciliation and settlement, especially for disputes related to public utility services, PUS. Mandate. It empowers the central authority, NALSA, or the state authority, SALSA, to establish permanent Lok Adalats by notification. Purpose. These adalats are set up as permanent bodies.
Indian Evidence Act was enacted in 1972, 1872, 1955, 1986.
The correct answer is 1872. The Indian Evidence Act was enacted in 1872. It came into force on September 1st, 1872.
Which is the correct statements with the regarding to the professional ethics of the lawyer? A. The lawyer who have no rights to go to the strikes or call the giving boycotts. B. An advocate shall not be influence any decision of the court of any illegal or inappropriate means. C. An advocate abusing the process of the courts and the guilty of the misconducting. D. All of the above.
The correct statement is D, all of the above. All three statements correctly reflect the professional ethics and duties of a lawyer in India as established by the Bar Council of India (BCI) rules and numerous Supreme Court judgments. Strikes and boycotts. A lawyer has no right to go on strikes or call for the boycotting of courts. True. The Supreme Court of India.
Derogatory administration is a systems of administration. A. French systems, British systems, American system, Irish system.
The phrase administration is a system of administration is a very broad and somewhat circular statement that requires context to be meaningfully answered. However, based on the historical development and establishment of the modern professional administrative machinery that serves as a global model, especially in Commonwealth countries like India, the most influential system of administration is the British systems.
Which act is covering the cyber crimes?
The primary legislation covering cybercrimes in India is the Information Technology Act 2000, IT Act 2000. The IT Act 2000 provides the legal framework for electronic commerce, legal recognition of electronic records and digital signatures.
In the tort of conspiracy, the purpose of the combination must be to A. Violate legal rights of the victims. C. The cause damage of the victims. C. Obtain benefits from the combiners. D. The perfects of interest of the combiner.
The correct statement regarding the purpose of the combination in the tort of conspiracy is most closely related to B. The cause damage of the victims. While option B is slightly vague, it captures the essential element. The combination's ultimate goal must be to inflict damage or injury upon the claimant. Tort of conspiracy. The tort of conspiracy involves two or more parties combining to perform an action that results in injury or loss to a third party. There are two main types, both of which require the ultimate result to be damage. 1.
Cancellation of the instrument is mentioned in Section 825 of the Special Relief Act, Section 26 Special Relief Act, Section 31 to 33 Special Relief Act, Section 36 to Section 42 Special Relief Act.
The cancellation of an instrument is mentioned in Section 31 to 33 of the Specific Relief Act, 1963. Cancellation of instruments. The provisions concerning the cancellation of a written document, instrument, are found under Chapter 5 of the Specific Relief Act, 19...
Unfair labor practiced by the employers. A. Victimization. B. False implication of criminal cases. C. Untrue allegations of absence without leave. D. All of the above.
All the statements listed, A. Victimization, B. False implication of criminal cases, and C. Untrue allegations of absence without leave, are examples of unfair labor practices, ULPs, committed by employers. These practices are prohibited under the Industrial Disputes Act 1947 and are specifically detailed in the fifth schedule of the Act, which lists various ULPs by both employers and trade unions/workmen. Unfair labor practices by employers. The fifth schedule outlines several categories of unfair practices by employers, which are summarized below. 1. Victimization and false allegations. The Act prohibits the discharge or dismissal of workmen using malicious or dishonest means, which includes all the options provided. A victimization, discharging or
Coastal Regulation Zone was issued by the central government in 1986, 1988, 1991, 1997.
The original Coastal Regulation Zone (CRZ) notification was issued by the central government in 1991. This notification was issued by the Ministry of Environment and Forests (MOEF) on February 19, 1991, using the powers conferred by Section 3 of the Environment Protection Act 1986. CRZ Notification History 1986. The foundational law, the Environment Protection Act 1986, was enacted, which provided the legal authority to the central government to issue regulations like the CRZ notification. 1991. The first Coastal Regulation Zone (CRZ) notification was issued, classifying coastal stretches into 4 categories: CRZI, CRZ2, CRZIV, and imposing restrictions on setting up and expanding industries and operations in these areas. 2011 and 2019. The 1991 notification was subsequently superseded by revised notifications in 2011 and the latest one in 2019, reflecting evolving needs for coastal conservation and development.
Who is lawful guardians? A person who is a law represents the minor. B. A person who has been appointed by the court. C. A person who has been authorized to represent an unmarried daughter. D. All of the above.
The term lawful guardian encompasses all the roles described in the options, as it refers to any person who has the legal authority to care for or represent a minor or.
Under the Companies Act, every person subscribing a memorandum of a company must take at least 100 shares, 20 shares, 10 shares, 1 share.
The correct answer is 1 share. Under the Companies Act 2013, every person who subscribes their name to the Memorandum of Association of a company limited by shares must agree to take at least 1 share, or not less than 1 share, in the company. This requirement is fundamental because the subscribers are the first members of the company. By signing the memorandum, they are deemed to have agreed to become members and are allotted the shares they subscribe for upon the company's registration. The minimum number of
GST comes into force from
The Goods and Services Tax, GST, came into force in India on the 1st of July 2017. This marked the implementation of the 101st Amendment to the Constitution of India, which replaced a complex system of multiple central and state indirect
2018 का
taxes with
पेपर
a single
कंप्लीट
unified tax structure.
ये 3 सेट्स हमने कर लिए हैं 2 सेट्स और हैं इसके बाद फिर हम और निकालेंगे और अभी के लिए करते हैं बाय नमाज पढ़ के आते हैं उसके बाद पढ़ते हैं तो मिलते हैं थोड़ी देर बाद